Good afternoon. In this video, I will be covering false imprisonment under law of tort. When we talk about the false imprisonment, it is something which is talking about an act which is punishable under the criminal law. So we need to get the familiar with the definition first. When we talk about false imprisonment under law of tort, it is classified as an intentional act. It is an act which is punishable under the criminal law. Under law of tort, when we talk about, so a person commits false imprisonment when he commits an act of restraint of another person which confines the person in his bounded area. So wrongful imprisonment occurs when a person who does any legal act of justification is intentionally restrict another person from exercising his freedom. And when someone intentionally restrict another person freedom, he can be bound liable for the false imprisonment in civil and criminal courts. The factor which constitute false imprisonment are probable cause of imprisonment, plaintiff knowledge for imprisonment, and intent of defendant during imprisonment and confinement matters, like period matters which are there. So this is applicable to the both private as well as government detention under criminal law. Whether the restraint is total or partial, the same is actionable. And when the restraint is total, the person is prevented from going out of a certain, circumscribed limit, which the offence is that of a wrongful confinement as defined under section 340 of IPC. So under IPC, it punishes the wrongful imprisonment, and from section 399 to 348. So when it comes to police, for proving false imprisonment is sufficient to obtain the writ of habeas corpus, it is mandatory that the person should be behind bars and should be confined in areas where there is no possible way of escape, and except the person will who has confined him. Depending on the lack of a particular jurisdiction, wrongful imprisonment can also be a crime as well as intentional tort. So elements which are considered with regard to false imprisonment are that all states these are the laws must be regarding the false imprisonment designed for the protecting people from being confined against their will. The law of each state vary in general. Certain constituents of false imprisonment must be prevented in order to prove a certain legal claim. In order to prove a false imprisonment claim in a civil suit, the following elements should be present. First is the willful detention. False imprisonment is something, or restraint is something which is intentionally or willfully. So accidentally closing the door when someone is on the other side is not a wrongful confinement or a false imprisonment, and willful detention applies to the intentional restraint in any form, including physical restraining a person from a person from restraining a person exist physically locking him in a building room or from other places, and restraining him from leaving through force or intimidation. The intention factor is also there. So generally the tort of false imprisonment must be intentional. A person is not liable for the false imprisonment unless his or her act is done for the purpose of imposing a confinement or with the knowledge of such confinement to substantial certainty which will result from it. For this tort, malicious is irrelevant. It is ordinary upon the judge to determine the evidence as the question of fact, and intention defendant is in action for the false imprisonment. Knowledge of the plaintiff, when we talk about the detention of another person, would have been wrong. There is no requirement that the plaintiff claiming another person for the false imprisonment was aware of his restraint on his freedom at the time of the confinement. So in the case of Henry versus Boyle, it was held that such knowledge is essential, and in that case, a schoolmaster wrongfully refused to permit a schoolboy to go to his mother unless the mother paid an amount alike to him, and due to him, the conversation between the mother and schoolmaster was made in absence of the boy, and he was not cognizant of the restraint, and it was held that refusal to mother in the boy's absence and without being cognizant of the restraint could not be amount to false imprisonment. Another case which is there, Mehring versus Graham White Aviation. The claimant was asked to go to the room which with the two work policemen which from aviation company. So he asked why state would leave it to not told. When told it on a suspicion of the theft, he agreed to stay, and work police stood outside until the metropolitan police arrived. So unknown to him, they were asked to prevent him leaving. It was held that an act which fulfilled the requirement for a false imprisonment, even if the claimant is unaware of it at the time, still counts. So Mehring was entitled to damages. So the most common defense for the false imprisonment is the lack of one or more elements. For example, if the victim agrees to the imprisonment, then the wrongful imprisonment did not occur. And however, there are like defenses that can be used to defend a false imprisonment claim. So below, there are like common defenses for the false imprisonment claim, like valid arrest has to be there. False arrest claim are not valid if person was detained due to the unlawful arrest and due to arrest under law. So if like probable cause to consider a person to have committed a felony or engaged is wrongdoing, so in addition a person can legally detain or arresting a citizen without reason. So it consent to restrain a person whose consent to restrain or confine without the presence of fraud or coercion or misconduct cannot subsequently claim to the victim of false imprisonment. Therefore, voluntary consent to the false imprisonment is often defense to the false imprisonment. So there was this case called Robinson versus Balman New Ferry Company Limited, in which the plaintiff wanted to take a ferry across a river in order to get out from the wharf from which the ferry would depart. He held that he had gone through the turnstile while he managed by the defendant, and he noticed the either side made it clear the charging of using turnstile was 1 penny. Plaintiff gave the penny and went through the turnstile and waited for the wharf for the ferry to arrive and pick up, and plaintiff took decision not to take the ferry and change his plan. So he wanted to go to the turnstile, for which the defendant demanded payment, resisted by saying that if he wanted to turn the turnstile that he was supposed to pay 1 penny. The plaintiff refused to pay the penny. Defendant didn't allow him to use the turnstile. The plaintiff sued the defendant, claiming that they had falsely imprisoned him. The court dismissed by him by stating that if he walked through the turnstile, then he voluntarily agreed to take the risk, and if he would not pay a penny, then he will not be allowed to go back, and he would imprisoned by the defendant. So this is a complete defense of action for the false imprisonment and false arrest, and when probable cause is established by the cause, the action, the false imprisonment and false arrest completely fails, and it is stated that the probable cause test for the imprisonment and arrest is an objective one, which is not based on the actual crime of individuals, but on the base of reliable facts of information which would lead a person to take the usual precautions as an offender. So defendant, as an action of false imprisonment or false arrest, has established a probable cause of a lie tort from which he has no additional obligation to prove. Even if probable cause exists, the malicious intent will not support a claim. So sometimes imprisonment can be justified on the basis the defendant was acting in support of law. So blame of legal justification lies on the defendant. Thank you.